which is our liquor retail case study. So I've got here Loua. Loua is the retail sector lead for the Labour Inspectorate for the Employment Services Division of MBIE. Next to her, we've got Andrew Shaw, and Andrew is here. He leads the workplace law team for Lane Neave, where he is a partner and has worked very heavily in the sector, in the liquor sector as well. And lastly, we've got Matt Wilson, who's the Corporate Affairs Director for DB Breweries. Full bios for all of the people you're going to have in front of you over the next couple of days are in the pack. I really encourage you to read them because we have some super experienced talent with us over the next couple of days. So welcome to you all, and welcome to Loua, who'll be kicking us off.
So I'm the lucky speaker who has the first session after lunch. I hope you'll bear with me. So good afternoon, kia ora. My name is Loua Ward. As Sheridan said, I'm the Regional Manager for Counties Manukau up in Auckland, and I'm our national lead within Employment Services for Retail. So the Labour Inspectorate, for those of you who don't know what we do, are the regulator within employment services. We ensure compliance with employment minimum standards. We enforce legislation such as the Employment Relations Act, Minimum Wage Act and the Holidays Act. We have a range of enforcement tools that we use to identify non-compliance and take action based on the seriousness, nature and extent and degree of harm. So just a little bit about us before we kick off. Oh, hold on. John, I'm having a bit of technical difficulty. There we go. Okay. Right, so here are some headings from the newspaper, from the press, and online over the last year or two. So today we're focusing in on the retail liquor industry, and for every good, hard-working, law-abiding employer in the sector, there is a non-compliant one. We estimate about 40% non-compliance in the retail liquor industry, and the majority of non-compliant liquor stores that we have investigated are part of nationwide franchises, chains, or franchise-like businesses. So this is some of the media focus that has been on migrant exploitation in the liquor centre. There's been extensive coverage of cases in Canterbury, Auckland and Waikato. A fair day's work for a fair day's pay. I think that concept resonates as a New Zealand value that we all hold dear. Employers who are not following the rules tilt the playing field through undercutting other compliant businesses. And their actions impact the profit and profitability of businesses who play by the rules. So we need to keep a level playing field. Some recent cases. So, as the regulator, we've taken enforcement on a number of liquor cases recently. I just want to flag to you 5 key ones that we have prosecuted. One is the Paraha Partnership. They operated 2 liquor stores in the Waikato. We received a penalty in the employment court of $200,000 for migrant exploitation, and that's on top of them already having paid $250,000 to 6 employees. That was in October 2019. Another big one we had was Shalini Limited. They operated 2 stores, one in Auckland and one in Parakai. They received a $100,000 penalty, and that was on top of $96,000 they'd already paid to 7 exploited migrant employees. That was in June 2019. Most recently, Nikita Enterprises, they operated 10 stores in Canterbury. The penalty for that company was $125,000 for migrant exploitation, and that was in December, just gone. We've also had smaller cases, but still significant. Basra and Keller, a Papatoe liquor store that was in the media in December. That was $62,000 in penalties, costs, and arrears to 1 employee. So in that case, it was 1 exploited employee. So the scale sometimes is lots of employees, sometimes it's just a few. And then we had another one in Clendon Park in Auckland. The penalty for that one was $38,000. And that was for sustained non-compliance for someone we'd investigated previously. That wasn't migrant exploitation, but there was very bad practices, and it was continued non-compliance. And so in these cases, there's also recognition that the directors are personally liable as well for what happens in their business. So with the last example I gave, the $38,000 penalty, $20,000 of that was to the company and $18,000 was to the directors personally. And in addition to this, these penalties render the liquor stores unable to recruit or support visa applications for migrant workers, as the employers will be on the stand-down list for breaching employment minimum standards. We also have a number of cases also under investigation and in the Employment Relations Authority and Employment Court. So in addition to prosecuting and working with other government agencies, we have also been moving into the liquor licensing space. So in the Labour Inspectorate's view, liquor stores and directors who exploit staff or who have a history of sustained non-compliance with employment minimum standards should not meet the licensing requirements to sell liquor. Non-compliance with minimum standards by employers is anti-competitive and it gives them an unfair advantage over good businesses. So in 2016, there was a decision by the Alcohol Regulatory and Licensing Authority, so that's the national body that decide liquor licensing rulings, that they did not see a clear link between employment law breaches and the operation of taverns in relation to the safe, responsible sale and supply and consumption of liquor. So that has been a problem in terms of challenging and making the link between migrant exploitation and liquor licences. But the tide has started to change, and there's been two cases that have started to challenge this view. One was an Auckland District Licensing Committee decision where the chairperson, so the Labour Inspectorate put an objection into a liquor licence, and they said that that could proceed to a hearing. They said that there was significant concern regarding exploitation of workers in New Zealand, and particularly in the liquor industry, and that the application should stand or fall on the merits of the case. And secondly, which has been a lot of media about in January this year, a renewal for a Tokoroa bottle store that was not granted by the South Waikato District Licensing Committee. Now, in that case, there'd been a number of allegations of migrant exploitation. Those were not proven, but the committee cited a systemic pattern of illegal behaviour over 5 years that gave this company an unfair advantage in the alcohol industry. And so a Labour inspector was called as a witness to support and give evidence in that case. And they drew a clear relationship between complying with minimum employment standards and as well as managing fatigue through shorter shifts, rostering 2 people through busy periods, and the ability of the store to safely and responsibly sell liquor. So those are very good things from our perspective. So what are the next steps? We are actively challenging liquor licence applications where we have evidence of worker exploitation, either as objectors ourselves or as witnesses for local councils, the police, or medical officers of health. So we're working closely with our government partners in that area. Okay, so to come to the end, in terms of taking the next steps, so one of the issues that we're seeing in this highly competitive industry with low margins is the limited repercussions from the sector when it comes to non-compliance. So we've been working with Superliquor, as an example, who have taken steps to implement robust systems to try and assure compliance across its franchises. We are also working with another brand at the moment to do the same, but there are brands out there who have yet to take meaningful action. Franchises and brands have a real opportunity here to take responsibility for cleaning up their industry and ensuring that exploitation is not welcome or tolerated in New Zealand. And this is through putting in better systems and audit programs. So the Labour Inspectorate and Employment Services will continue to regulate the industry, but as was said in our previous panel, we can't regulate our way out of this. Our role is to drive demand for change and enhancements by highlighting risks and weaknesses through our enforcement work and associated publicity. We will also support business to make the necessary changes and enhancements with the number of resources we have. However, the liquor industry, needs to take responsibility too, and all franchises and brands and franchise-like businesses have a role in taking action to eliminate migrant exploitation in New Zealand. Thank you.
Kia Kia ora and good afternoon, everybody. I've got 8 minutes to talk about a very large and complex topic. Now, Jonathan's asked me to talk about, firstly, how Neave has become involved in the liquor industry and minimum entitlements, then to look at why it's important to put systems in place from a practical perspective, and then lastly, good measures that have been put in place in the liquor industry. So look, our involvement is not just in the liquor industry. We've been advising clients throughout New Zealand on minimum entitlements, both employers who are either intentionally or unintentionally breaching, but also employees who have had their rights breached. So we look at it from both angles. We were the counsel on the full court, employment court case, Labour Inspectorate and Pret a number of years ago, which set the boundaries for how you actually allocate penalties in the courts. And more recently, we've been extensively involved with Super Liquor, and I've spoken with Campbell, the CEO there, and he said I'm entitled today to talk about some of the things that they're doing. So that will help in the second two parts of what I'm going to talk about. So for me, there are, I think, 5 areas of minimum entitlements from a workplace law perspective. The first, obviously, is minimum wage. And as we know in New Zealand, 1 April, we're going up to $20. And it's interesting to compare this to some comparable overseas countries. If we look at, for example, in Australia, the minimum wage is about $21.35 New Zealand. In the UK, about $17.30 New Zealand. And in the US, on a federal basis, about $10, but on an average basis, when you take into account some of the states, about $16. Now, that's all in New Zealand dollars, and what it indicates to me is that we have a high minimum wage in New Zealand. Probably not high enough, but certainly it's a high minimum wage when we look at comparable countries. So what that indicates is that for employers who employ people close to the minimum wage, there's a real encouragement for them to breach their entitlements by paying them under the minimum wage because it is so high. Secondly, if we look at the living wage, New Zealand's living wage is about $22.10. In Australia, about $22.40 in New Zealand dollars. The UK, depending if you're in London or not, between $18 and $21. And the US about $23. So again, what we see for people who are paid close to minimum wage, the living wage is a step above that, some $2. So again, for them, they need to be paid the minimum wage and then some. And so the harm created by an employer who breaches minimum entitlements is more significant for those people who are paid at that lower level. The other areas where I see minimum entitlements being breached are, of course, the Holidays Act. And if anybody thinks that their employer is not breaching the Holidays Act, probably not right. And it's not because anyone's intentionally breaching it, it's because it's so difficult. And so the government now has 22 recommendations, which you'll be pleased I'm not going to go through here today. But those recommendations are designed to help the Holidays Act be a lot more user-friendly. And we do a huge amount of work in this area trying to help employers, most of them unintentionally breaching the Holidays Act. In the liquor industry, there's a number who are actually intentionally breaching, unfortunately. And we see it's because of the complexity. In the liquor industry, it's because of the ability for them to try and get a little bit back. Thirdly, employment obligations. And you can't underestimate some of these employment obligations, starting with having an employment agreement. I mean, it's vital that everybody has an actual employment agreement and that it's properly drafted with things in there that will allow an employee to understand what their rights are, but more particularly to allow an employer to understand what their obligations are. And then simple things such as rest breaks. And in the liquor industry, one of the real issues we find is solo workers, and this will apply to other retail areas as well. How do you give a solo worker a rest break? You know, there's obligations for paid 10-minute breaks and also unpaid half-hour breaks. So it's a real complex issue from an employment perspective, but also from a health and safety perspective. And there's a whole lot of other employment law issues you've got to be aware of, from KiwiSaver, contributions through to parental leave, and so on. The fourth one, which I'm not going to talk about today, of course, is health and safety in itself. The minimum entitlement for every worker going to work is that they go to work and it's safe and that they return home without being injured or harmed in any way. And as we know, injury and harm nowadays is not just about the physical injury and harm, but also about the mental injury and harm. And we heard before some of these people who are exploited working 14 to 16 hours per day, and that may be on week upon week. Now, there's already been one fatality which has been prosecuted by WorkSafe dealing with fatigue, and it was in the contracting industry where somebody was working on average about 16.75 hours a day, which was accepted in that industry because in contracting you do work pretty hard during certain periods of the year. And that was a prosecution where the person died as a result of that fatigue. And so what you don't want to see is workers who are forced to work 16 hours a day, then go home either on a bike or a car and are so fatigued that they kill themselves or injure somebody else. And lastly, of course, immigration, and all this links in as well. We've got a whole team at work that deals with immigration, so I won't talk about it here. But that's another minimum entitlement. If I have a passport, that's mine. I shouldn't have to pass it on to an employer. If I have a visa that's linked to my job with you, I shouldn't feel that because I'm linked to you, I can't complain if you're breaching my rights. And they are the real issues that we're finding. So in those 5 areas, what are some of the practical things that we need to look at from an employment law perspective? And I'll rely a little bit on what we're doing with super liquor. So some of the issues for super liquor have been around the education space. So we have been educating their franchisees extensively on their obligations as an employer in New Zealand. And for some of them it's come as a little bit of news because there are some complexities here they don't see at home. Secondly, with employees, we've been ensuring that they have rights to information. The 0800 number at MBIE is one example, but Superlic has their own 0800 number, and there are posters in the shops which tell them about their rights. Thirdly, we're ensuring that the payroll systems they're using are actually up to scratch. And as you would have seen a wee while ago, MBIE, one of the larger payroll providers in New Zealand, wasn't doing it properly. And that was all through the news. And so what we're finding is that we're helping to educate some of the payroll systems which then assist with super liquor to ensure that they're correctly calculating things. We also look at systems for working alone. How can we have people in that shop work alone? We're looking at the recording of wage and time, which is obviously a requirement in New Zealand, and to do it properly in accordance with the Act, but also recording holidays, again, properly in terms of what the Act requires. Because one of the problems with payroll systems is that data in is data out. If I give the wrong data, what's going to come out is going to be incorrect. We're looking at the health and safety culture in these organisations as well. And we undertake an extensive audit of the business, and we're now into our second round of audits for Super Liquor, and it's done by way of SurveyMonkey. We go out, we do an extensive audit, and we have specially designed questions for that audit, which are looking at trying to not catch people out, but ensure people are doing it correctly. And then from that audit information coming back, the experts in my team can look at it and go, this is not right. This is one of the issues that we need to examine further, and where necessary we'll examine further. The real issue here, though, is cash. I mean, nobody really carries cash anymore, but you'll find in the liquor industry, people are being paid cash, or liquor bosses are asking for cash back. And that's how we try and catch that is really difficult. I think it's a difficulty that the Labour Inspectorate has, and certainly we have. I can look at a payroll and I can look at an audit system and I can say this all looks right. They're paying the minimum entitlements of $20 an hour and holiday pay and so on. But I can't tell if they've been asked for that cash to come back. And so for me, educating employees to say, one, that's not right, you cannot have an employer deducting money from you, and two, you can be protected in terms of your migrant status in New Zealand is the way through. Because most of what we can catch on paper is only a small part perhaps of what is actually happening there. So education for employees and giving them protections and rights that they probably don't understand now is for me the way through. That's all I have, so I'm going to now hand on to Matt, I think.
Thanks, Andrew. Kia ora, good afternoon. So I wanted to just start by talking you through a little bit about DB, who we are, and the journey that we've been on recently, to give a bit of context to why I'm standing in front of you today. So for those of you that don't know, DB is one of the oldest and largest brewing groups in New Zealand. We brew products like Heineken, Tiger, Tui, Monteith's, also the Aotearoa Brewery just up the road here, and our base is in Otahu in Auckland. We've been for a while now fully owned by the Heineken Group, and Heineken is still a family-owned company, with the Heineken family having a controlling stake in Heineken. Also a Dutch company for Dr. Natalia, your presentation earlier. Now, I think one of the reasons that's relevant is I think Heineken and DB has a very strong values base, partly because of the family ownership, but we're both equally vested in sustainability. Heineken has a lot of ambition at a global level, but here in DB we do as well. And that goes both from an environmental perspective and our ambition around by 2030 using only clean energy in our production sites, balancing all of the water that we use and creating zero waste to landfill. But equally it applies from a social sustainability perspective. And that's why the last few years in particular, our focus has been more on drink driving, but increasingly we've grown concerned about issues around particularly worker exploitation and specifically in traditional liquor stores. And our viewpoint here is pretty simple. We want to see bad operators exit the industry and we want to see good operators stay in the industry, not the other way around. We've got a very vested interest in making sure we've got a sustainable industry that we can continue to supply. And that has led to a lot of thought and discussion in our boardroom and in our corridors the last year in particular about what role can we play as a supplier. And I think it's logical, and a lot of you probably ask yourself, well, surely that's simple. Surely you can just cut off supply and not supply some of these stores. The reality is a little bit more nuanced than that. And there's two reasons why. One is that actually a lot of stores don't buy direct from us, they buy via wholesalers. And even in that case, they might buy via a buying group. So even if we decided not to stock them anymore, they could still buy our products should they want to. The other, probably bigger reason though, is that we also need to recognise due process. And if these stores in particular are being investigated for allegations around worker exploitation, or it could be other offences as well, we need to be careful about not overstepping our mark and trying to play the role of judge, jury and executioner as well. The difficulty with that though is that those are reasons not to do anything as opposed to reasons to act. So we've thought more about this, and where we've landed as a business is that where we see particularly egregious cases of worker exploitation, criminal convictions, or simply a path and a history of not treating workers well, we will object to a licence renewal or potentially a new licence that's wanting to be issued as well. Now that's a difficult place to be in, as some of you might imagine. From a customer perspective, it creates certain risks, but equally from the perspective of how we articulate what is a case where we will take an objection and where won't we. And that's something that we don't have all the answers to today. You know, some people will say, actually, you should be doing a lot more. Others will say, we've got no role to play and we shouldn't be trying to object in that process in the first place. Others, again, will say we're going to pick and choose who we object to based on commercial reasons, not legal or moral reasons. We don't have all of the answers to that. All that we know is that we've seen enough in this space that we want to take a stance. We're going to work it out as we go. And the key role that we can play for now, and this might evolve in the future, is actually landing an objection. But what we have determined is that if we do object to a liquor licence, and that store is ultimately granted or renewed its licence, we will continue to supply, because we'll respect the judgment of the licensing authority. But the place where we are today and what we're comfortable to do is to say, actually, we want to step out from just being a supplier and actually physically object to some of these licences as we see them come up. Hopefully that stirs up some good discussion, and happy to take your questions with the rest of the panel. Thank you.
That's fantastic, thank you all. And as I said at the beginning, Matt, it's really great to have someone from the industry brand actually being present and being part of the conversation. So really good stuff there. So before we go to questions, I just want to draw out from the panel, you know, some of the complexities of this case as an example for possibly other sectors in addition to liquor. So we've got a pretty convoluted value chain here where we've got the brands, the local concessionaires, the franchisees and the owners of the franchises themselves, and plus the owned stores, I suppose. We've got you know, characters running franchises who are bringing workers into the country and exploiting them. and obviously we've got customers going to the store to buy the product, which could well be your branded product that they're going to the store to buy. And kind of in the middle of this example, we have the Liquor Licensing Authority, and your licence to operate can be taken from you or given to you depending on how your behaviour is. Does that? It feels to me like we can't really expect the Liquor Licensing Authority to kind of solve this problem for us. Has anyone got a comment on, are they the right agency to be wading into employment practices in the sector, or are they really just a convenient means of being able to pull the pin on someone? Any thinking around that?
So, working?
Yep.
So one of the things that we're cautious about doing is not moving determinations around employment matters into the liquor licensing space in terms of serious exploitation, and I think that that's a space that they don't want to be operating in either. So for us, when we have situations where we're taking a case or we're taking a prosecution to the court or to the Employment Relations Authority, we do tend to wait until we've got a determination, and so that takes care of the big cases. But yes, the industry is quite large, and as I said, one way that we think that this could be dealt with better too is through the supply chain and through franchisors taking responsibility to make sure that that's not happening in their business. Because as you can see with the DB example, the brand is very important to companies and their values and sustainability, so I think it's all linked together.
Yeah, fantastic. And is this, do you think, something that is endemic within the liquor industry? And you talked about 40% of actors potentially being non-compliant, which strikes me as being a huge number. Is this a liquor industry thing? Is this a franchising thing? Is this a retail thing? Where do you think the opportunity for failure exists in this value chain or in this story? And any of you feel free to chuck in an answer here.
I think we see this in all industries, not just in the liquor industry. I think any industry where you employ people close to the minimum wage, you're going to find the ability for breach. Where you're well above the minimum wage, I think I see it less often.
And another risk, Andrew's right, is also in culturally vertically integrated business models. So models where it's the employer comes from one ethnicity, they employ staff predominantly from the same ethnicity who may not understand their rights. And we do see that throughout the liquor industry in terms of the stores, and also they are hiring people close to the minimum wage.
Great. So it sort of strikes me that from a control oversight perspective, the licensing authority's got its job, but this must be happening in other franchise systems and in other retail businesses and obviously supply chains around New Zealand, way beyond liquor.
Just to add to that though, Sheridan, I think it is relevant in the sense that you've got an authority that has a test to grant a licence based on character.
Yep. Great.
And I think that's where we see there's a bigger role for the licensing authority to play.
Yes.
And it's, I think a little sad and unfortunate that it's taken until this recent case in Aotearoa that the authorities actually said who you are as a person and your employment practices are relevant to whether you hold a liquor licence or not. Because I think for most of us in the room, it should seem like common sense that your wider character is the very type of thing that should be taken into consideration when working out should you be able to sell alcohol or not.
Absolutely, and we've seen other industries some time ago now, but like real estate agents, where that test of character and that oversight has been changed. That's now Ministry of Justice. They've got their own oversight authority, plus their own kind of justice system as well. So it's a very strong, very high bar for them.
And one thing I'd note as well is we're focusing on liquor today, but it is a subset of retail, hospitality,
Yep.
and we are doing work in those sectors as well.
Absolutely.
Because we identify there are risks there.
Yep, great. And just a sort of a last question before we open it up, and this talks a bit to some of the very powerful comments that you made at the end there, Matt, about, we don't want reasons not to act, we want reasons to act, and also, comments about how do we reward high performers while weeding out the bad performers, but we don't want to penalise everybody. in a sector with onerous rules or expensive compliance frameworks, when actually there are some parties out there, 60% of the parties are actually doing a great job, and some of those will probably be doing an excellent job. So any thoughts around how to reward good? Are there any mechanisms in place at the moment that do tend to support that notion?
Yeah, I think in some ways it feels a little bit perverse to reward someone for complying with the law. In one sense, look, there are franchises like Liquorland, like Superliquor, that are doing a very good job. I think the thing that would really reward them is if we actually penalise and fix the bad operators. That levels the playing field, and that makes it easier for the good franchises and the good stores that are complying with the law, because they're competing like for like. They're not competing with a store that can hit margins or can hit price points that they can't hit because they're paying their workers the minimum wage or above.
And so does the consumer have a role in rewarding the good players? And if so, how? How do we know as a consumer that this employer's gold standard and this employer's maybe not?
Yeah, I mean, I think to a degree, and I guess at the moment it's worked more again in the inverse, that operators that have been called out publicly in the press, and Loua presented some of the stories today, once those operators are known, I think there is a little bit of a flight away from them to the better operators. But there'll always be an element of price and convenience in there as well.
And I think from a franchise position, if you have a franchise agreement, within that you can reward the good players in your system and through rebates or what have you. But also, I think for those franchisors who, as Matt said, talks about doing what's right, as Superliquor has, if you are breaching the law, then you're out of the franchise system. The problem, of course, is that they've got to set up under another name.
But to that, do you think more and more that you're going to see franchise agreements set up that take culture, behaviours and values into account so that the franchisor can actually terminate an agreement for just simple bad behaviour?
Yeah, absolutely. I think that's exactly where we're going. I mean, the consumers are demanding more and more sustainability in the places they purchase from. And same with franchisors. They will demand that their people who keep their brand ensure that their brand is kept to the highest standard, actually maintain sustainability, and that comes back to not exploiting workers and treating them as well as you can.
Absolutely.
I think there's an opportunity there for franchisors to use that as a point of difference, to say, yes, we are putting these steps in place, we do have these processes, we have these audit mechanisms, so that consumers know that.
Absolutely, I agree. Okay, gang, have we got any questions from over here? Where's our roving microphone? Who's closest? Simon? I'll go there and then I'll bring the microphone.
Kia ora, I'm Jerry Ward from EY. Just in terms of that cultural factor that's been talked about in the previous panel and this one, when people are subject to a particular situation, this might be a question for Cheryl and Cam as well, but how do you get at people in order to educate them better, I guess, and empower them? If the people that are new migrants to New Zealand are working for someone of the same culture and are therefore subjected to a perceived requirement, as it's been referred to, how do you get at them in order to educate them?
Yeah, that's something that we're focusing on as well as information and education. So we have links with community groups, with community law officers. We put out material in different languages, like for the liquor store industry in particular too. We took our some of our pamphlets that talk about basic rights and potential indicators of migrant exploitation. We've translated them into Hindi, into Punjabi, into simplified Chinese. And with our proactive work, been getting those out to the stores and giving them to workers and trying to push that messaging out there. So it's through a number of different mechanisms, but I think also the people in the room, through the unions, through the community groups, by educating them, they're able to get out there, explain the rights to people so that they can come forward and get protection.
Yeah, I'd like to pick up on the union point. It's difficult for an employment lawyer to promote unions, but I think in this case, First Union First Union spoke very well. It's the Migrant Unions Association. Because if you come from another country, you may actually not trust our government. Because in their country, not trusting their government. So I'm sitting here, all due respect to Emily, who I trust implicitly, you know, they might look at it and say, well, that's the government, are they going to help me? Whereas a union, they may see as helping them because they're a collection of, you know, similar people. And once you get a couple of your friends and then people from your own culture, that may well assist.
Great. We had one question over here.
Anu Kaloshi from Migrant Workers Association. There's quite a few things I would like to say, but I'll keep it very short. I think people, workers, exploited workers, are genuinely fearful of going to authorities. So they feel somewhat more comfortable coming to sort of community groups. So as a result, we, in the last 10 years, have interacted with many, many workers. And actually, the very first worker we assisted was a liquor shop manager in Papatoe. I think the underlying issue here that we have seen over the years is the practice of attaching visas to employers. That is what ultimately drives the workers that they will put up with whatever comes their way for that ultimate goal of getting residence here. And that they come here as international students or on work visas, and there's always that goal that this can lead to residence, education can lead to residence here. So they're on a journey here. So for the employer to keep threatening them that if you don't work the extra hours, if you don't do X, Y, Z, I will have your visa cancelled and I'll have you deported. That is the biggest fear for a migrant worker. So, we, alongside many labour unions over the years, have been calling for that practice to be stopped. To me, that is modern-day slavery, that's bondage. I think we also need to talk about that here in this forum, that we must stop attaching visas to employers. I think once we do that, I'm quite confident that we will see radical changes in a very short space of time. So as well as having an anti-slavery act and stopping human trafficking, because a lot of the exploitation that we have seen in the last 10 years doesn't quite fall at the other end of the spectrum, that we would call it slavery. It's kind of somewhere in the middle. So, and I'm heartened to see that, there are more cases like, Loua cases, we're seeing more and more in media. But fortunately or unfortunately, I know several of those employers, and they're still quite well respected within their communities, which is a real sad thing to see.
And I certainly think some of the issues you're raising are issues being spoken to in the action plan that the Minister's released this morning, in terms of some of the actions the government's looking at, like the visa that doesn't put the worker in that terrible situation where they're damned if they do and they're damned if they don't. And I think there's more discussion on that tomorrow as well, but certainly in that action plan there is a plan to contemplate a visa that is not fixed to the employer for that reason. I've got a question over here.
Mike Treen from Unite Union. So we've dealt with liquor shop cases, dealt with contractors in the construction industry, Chinese companies, but we also deal with major fast food companies that run franchises and make their franchisees obey the law. And so, McDonald's, for example, it's very unlikely that a McDonald's franchisee will breach minimum standards. The company has auditing processes and sends people in to interview workers to find out what's happening to them. And there's no way a franchisee can hide what they're doing from head office, and head office ensures that they are all part of the collective agreement with Unite Union as well. Another major company, Restaurant Brands, is, in my view, doing the sort of opposite situation. They are franchising their Pizza Huts because I think they can't make money, and they know, essentially, that in order to run them, you have to run them as close to the legal or below the legal minimum, and they don't want the franchisees part of the collective agreement. So, that's the sort of problem that we face at major companies. So I think the companies, the head franchisees, the head contractors, where subcontracting is involved, have to be part of the legal liability, so that if one of their franchisees or subcontractors offends, then they have a duty to be part of financially fixing it for the workers concerned. Then they will make sure that their subcontractors obey the law, that their franchisees obey the law, if they are at least partially liable or fully liable for offences that happen.
And it's an interesting concept, because one of the speakers earlier on talked about the fact they look at it like health and safety. And of course, under the new Health and Safety at Work Act, the PCBU is accountable for the health and safety breach, regardless as to whether the person who actually employs the person who got injured. So I certainly think that thinking is going to be included in any thinking about how the modern slavery legislation, if it comes to fruition in New Zealand, would occur, because it strikes me it's pretty similar stuff. Has the panel got anything to say about any of the issues raised from either of these two floor comments before we wrap?
Yeah, thanks, Mike, for your comments. The difficulty with franchises are a commercial arrangement, and you're right, the head franchisee should take more control. I think the likes of Super Liquor are certainly doing that. It comes back to reputation. So that is why the supermarkets of this world will do this. And we've seen a number of major corporations that are franchised out around the world where they've been slammed because one of their franchisees has done something wrong. So for me, certainly that reputation piece for the very good franchisors is a very important part to ensure that they're doing it right. And as Sheridan said, under the Health and Safety at Work Act, you're supposed to consult, coordinate and cooperate with your people that you have same duties as you. So it'd be nice to see something like that in employment law, but not yet.
Yeah. Thank you very much for that.
Yes, and I would say in addition to franchises, the same principle applies to franchise-like businesses, where in the customer's mind they're buying a particular brand, they are a number of stores that all look the same, talking about liquor, the same liquor stores, they associate one liquor store with the bigger company, and so that's what we're looking for in this industry as well.
Yeah, fantastic.
First of all, acknowledge the leadership, Matt, of you and DB. I guess my question was, do you sense any similar leadership ambition on the part of other players in the industry at your level, the likes of the Kirins, the Constellations, the Pernod Ricards, that kind of level?
Yeah, for sure. And it's something that has been discussed in those industry associations, and I'm sure they won't mind me saying in the room today, you've got representatives from some of those other entities, from wine growers, hospitality. So it very much is. I think, like we are, we're all very much on a journey in trying to work out exactly what's the right role for us to play and how does that manifest. But it is something that's actively discussed. I think, like the discussion of picking up on Mike's point, with franchisors as well, you have a spectrum. You have the super liquors and the liquor lands. You also have what look like unbanned stores that are actually buying groups. The wider industry is a little bit the same, where you do have a spectrum. But there's definitely an active discussion, there's definitely a willingness to do more. It's just a case of understanding better what is our role and what can we do in the most credible way.
Great, thanks. Well, that has been a great session, and to Matt, Andrew and Loua, thank you very much for joining us today. So let's give them a round of applause, and we're on to the chorus session now.